Hello everybody, I hope you're well. Thank you to everyone who joined our client webinar last week with myself and Chris Carhill. I hope you found it informative, and I hope you received the link to the recording which was featured in our last newsletter. If any of you have any questions about the content or indeed anything else we've covered over the last few weeks, please do let me know. Today I'd like to talk to you about the value of having a robust financial safety net in place. I'm not going to mention the C word this week as, like you, I'm exhausted hearing about it, but recent events have given us all reason to think about our health, our families, our finances, and the security of our jobs and income, amongst other things. As a result, my solicitor colleagues have been seeing a sharp rise in inquiries about wills and lasting powers of attorney over the past few weeks, and we have started to review clients' protection needs again. I'll come back to talking through the implications of not having an up-to-date will and LPA in place later in the video. But before, I'd like to talk about the importance of having a financial safety net in place for your family. I know it's not an easy subject for many of us to think about, but recent weeks have certainly showed us that none of us can ever really know what's around the corner in life. So bearing that in mind, now is a really good time to do a risk audit on your family finances. One of the main, but admittedly more uncomfortable questions to ask yourself is what the financial implications would be for you and for your family if you got sick, you were unable to work, or if you were to pass away. When I'm sat with clients discussing this area of their financial planning, I usually ask them to think about what they would want to happen and what financial position they would want themselves or their loved ones to be in if they either couldn't earn income or if they weren't there anymore to bring an income into the family home. Most clients would say that they ideally wouldn't want theirs or their family's standard of living to particularly change. The question I then ask them is whether the plans they currently have in place would enable this to happen in reality. What would your answer be to that question? There are a range of insurance plans which can help cover your family and give you the peace of mind that your loved ones will be financially stable. However, the more straightforward bit of financial planning you can do is to ensure you have an adequate emergency fund held in a cash account which could pay your essential household bills and family expenses for between 3 and 6 months. There are a range of insurance plans which can help cover your family and give you the peace of mind that your loved ones will be financially stable. However, the more straightforward bit of financial planning you can do is to simply ensure you have an adequate emergency fund held in a cash account which could pay your essential household bills and family expenses for between 3 and 6 months. Beyond this, I would always encourage clients to, at the very least, have any debts such as mortgages insured against sickness or death. Additional insurances such as income protection, critical illness, or lump sum life cover to create an income for loved ones or a legacy for children can then be added as appropriate, taking into account any cover offered as part of your employee benefits packages. Everyone's needs will inevitably be different, so Dan Riley in my practice is happy to discuss new or a review of existing insurance plans with you to determine what you need and whether what you already have is still appropriate. As well as reviewing any of your existing policies, Dan can compare the premiums on offer from multiple providers in order to get a competitive but comprehensive policy quotation suitable for your individual or joint needs. Moving on now to other areas. Firstly, let's touch on power of attorney. I know that some of you have had or have a lasting or enduring power of attorney in place for your parents, even if you haven't got round to making them for yourself. Lasting power of attorney, or LPA, is the current version and is split with one LPA covering property and financial affairs and the second covering health and welfare. Most of the long-term care work I do is with adult children who have these in place for relatives who've lost capacity or who are now going into a care home setting. However, very few younger people think about having an LPA in place for themselves. In fact, in a recent survey, 45% of people aged 45 and over knew nothing about LPAs. The source of that's from the Office of the Public Guardian. And when told about LPAs, 61% weren't interested in setting one up in the future. That research was done by Mori. But what would happen if you or your other half suddenly lacked the capacity to make decisions for yourselves? How would you ensure that your wishes are respected and your financial and welfare interests protected? Let me give you a couple of examples. The businesswoman. Lynn ran her own retail business worth £1 million before she developed early onset dementia. No longer able to manage her own affairs, her husband Tim needed access to Lynn's accounts in order to sell the business and pay for her care. Lynn hadn't made an LPA, so Tim had to seek a deputyship order from the Court of Protection to do this. The application took over 6 months to complete. During this time, no one else could run the business, resulting in significant difficulty, both for the business and for Lynn and Tim. The next example, the married couple. Alison had an unexpected stroke and was forced to move into a care home. Alison and her husband Andy co-owned a house worth £400,000 and Alison had investments worth over £250,000. The local authority assessed Alison, and as her assets were over a certain threshold, she was deemed fully liable for her care fees. Andy was subsequently asked to pay these fees at a rate of £2,000 a month. Andy had to apply for a deputyship order, but the care home fees mounted quickly and the care home required payment. Andy couldn't access Alison's investments and had to take out a loan to cover the fees. If an LPA had been in place, he would have been able to have covered the costs immediately. And one example of what happens when you do have an LPA in place. Lucy ran a successful business. On a holiday to Portugal, she had a serious accident and was in an induced coma for 6 weeks. During this time, her partner Mark was able to run her business, paying wages, signing contracts, and dealing with the day-to-day management, as Lucy had previously set up an LPA to enable Mark to do just that. Lucy eventually recovered and returned to her business. Without an LPA, the business would have been unable to operate successfully. If hearing these stories has made you think that you need to either review or arrange a new LPA, please just get in touch. If you don't have your own solicitor to do this for you, I can happily put you in touch with a local solicitor who'll be able to help you. Finally, I want to talk about wills. A will is something that should be reviewed on a regular basis, as it sets out not only who your assets will go to when you die, but also at what age or stage of their life you want them to receive those assets. We've all read about family disputes and heartache caused by someone dying without a will. Let's take a more extreme but topical example of the pop singer Prince. Prince died in 2016 and left a massive estate, believed to be worth hundreds of millions, but it's still unsettled, still not officially valued, and still not distributed to his heirs, his 6 siblings. According to articles in USA Today from April 2019 and MSN News from February 2020, platoons of lawyers have been working on it for 4 years, racking up bills, arguing with each other, arguing with the heirs, arguing with consultants hired to advise on various estate matters, and filing blizzards of documents and paperwork with probate court, which has made little progress in its mission to sort the estate out. So far, administrators have spent $45 million, including $10 million in legal fees, and his siblings have yet to receive a penny. None of this would have happened if Prince had had a will in place. And a personal example from someone I know, Jane, not her real name, was married to Dave with 2 children. They divorced and Dave remarried Catherine, who had 2 grown-up daughters from a previous marriage. Tragically, Dave died in a motorbike accident and didn't leave a will. All of his estate went to Catherine, who has since rewritten her will to say that eventually everything will pass to her children, Dave's stepdaughters, and not to Dave and Jane's children. Jane is understandably devastated by these events, but all of this heartache could have been avoided if he died with an up-to-date will. If you'd like to learn more about wills, the rules of intestacy, or lasting power of attorney, please take a look at the documents attached to the email, which will provide more information, or contact me with any specific questions. I hope you found the content of this video of interest. As ever, please let me know if you have any questions or if you need any advice on any of the points raised. Equally, if you have any family, friends or colleagues who need any financial advice, I'm more than happy to chat to them to see if I can help. And if I can't answer their questions, I'm in regular contact with legal, accountancy and business professionals I know who I can put them in touch with instead. Once again, thank you for listening. Until next week, stay safe and stay well.